Good morning. In the challenge of crime in a free society, the President's Commission recognized the influential role that prosecutors play in the administration of justice. Although the report characterized the exercise of discretion by prosecutors as necessary and desirable, it also lamented the fact that prosecutors often exercise their discretion in ways that made inappropriate and ill-advised decisions all too likely. The President's Commission noted that the high volume of cases prosecuted in large urban courts led to the adoption of informal, invisible administrative procedures for handling offenders and a reliance on negotiated rather than litigated outcomes. Other problems cited were first, that prosecutors typically did not have protocols or guidelines to guide them in making charging or plea bargaining decisions or sentencing recommendations, and second, that they often did not have sufficient information about the crime or the characteristics and needs of the offender, and thus were unable to make informed and appropriate decisions about the handling of the case. As the Commission stated, prosecutorial decisions were all too often made hastily and haphazardly, and were seldom subject to oversight or review. As a result, the Commission concluded, it is surely safe to assume that many mistakes are made. In its report, the Commission targeted two aspects of prosecutorial decision-making, charging and plea bargaining. In order to ensure that decisions to dismiss or to charge were made fairly, appropriately, and consistently, the Commission recommended that prosecutors be provided with standards and guidelines to follow in making these decisions, and that especially in felony cases, they be required to provide written reasons for rejecting charges. The Commission also acknowledged that many offenders who find themselves in the arms of the law require supervision and treatment rather than punishment, but that prosecutors' options for dealing with these offenders were limited by alternatives, the lack of alternatives to prosecution. To address this, the Commission recommended the early identification and diversion to other community resources of these types of offenders who did not appear to need criminal prosecution. With respect to plea bargaining, the Commission acknowledged that plea bargaining served a number of important functions, but it also pointed out that negotiating pleas, which was informal, highly discretionary, and largely invisible, was subject to abuse, both by prosecutors who overcharged in anticipation of a guilty plea, or who threatened defendants with harsher punishment if they refused to plead guilty, and by dangerous defendants who were guilty of serious crimes who used plea bargaining to obtain inappropriately lenient sentences. To address these problems, the Commission recommended that plea bargaining should occur early in the process, should involve a full and transparent exchange of information between the prosecutor and the defense, and should produce a negotiated disposition that would be presented to the judge before the defendant enters a guilty plea. The report recommended specifically that the prosecutor and the defense attorney should acknowledge explicitly the terms of the plea agreement, and that the agreement should be entered into the court record at the time that the defendant enters a guilty plea. 50 years ago, the Commission also recognized or acknowledged that the revolution of scientific discovery has largely bypassed the problem of crime and justice. In a chapter entitled Research, Instrument for Reform, the Commission stated that its analysis of law enforcement and the administration of justice revealed that the greatest need was the need to know. Now, the Commission did not specifically single out the exercise of prosecutorial discretion, but it is clear now, as it was then, that we know relatively little about this important aspect of the administration of justice, unlike the juvenile justice system. Despite their importance, prosecutors' charging and plea bargaining decisions have not been subjected to anything approaching the level of scrutiny that has been applied to judges' sentencing decisions. I think that this reflects the lack of transparency that characterizes most prosecutors' offices, the lack of publicly available data on charging and plea bargaining, and the relatively small amount of funding allocated for this type of research. Now, over the past 50 years, research on prosecutors' charging and plea bargaining decisions has become more theoretically grounded and methodologically sophisticated. It has moved from largely descriptive examinations of policies and practices to more nuanced explanations designed to explain how decisions are made and to identify the factors that affect charging and plea bargaining decisions. This research has also become more transdisciplinary, with economists, legal scholars, social psychologists, and political scientists examining prosecutorial decisions through different disciplinary lenses. Given the power that prosecutors exert over defendants and case outcomes, there is an obvious need for additional research on the exercise of prosecutorial discretion. The past 5 decades also have witnessed a number of changes in policies and practices related to the exercise of prosecutorial discretion. Although initially reluctant to interfere, the Supreme Court has issued a series of rulings that attempt to regulate and constrain prosecutorial discretion in both charging and plea bargaining. There also have been policy changes designed to improve prosecution and enhance justice at both the state and federal levels, as well as innovative proposals for addressing the problems inherent in plea bargaining. So what recommendations would a 21st century commission make regarding the exercise of prosecutorial discretion at charging and plea bargaining? Such a commission would likely echo the earlier commission's call for more transparency and accountability in the decision-making process. This would entail such things as implementing guidelines and standards for making these decisions, requiring prosecutors to give detailed reasons for rejecting charges, and requiring that the terms of the plea agreement be stated in open court and on the court record. A 21st century commission also likely would reiterate the earlier commission's recommendation that prosecutors use their discretion to divert from prosecution marginal offenders and offenders who need treatment rather than punishment. To this end, it would encourage the greater use of problem-solving courts and community prosecution, and the promulgation of policies that allow prosecutors to use their discretion to reduce the reach of the criminal law by not prosecuting certain types of offenders, and the punitive bite of the sentence by not filing charges that trigger mandatory minimum sentences or habitual offender provisions for certain kinds of offenders. Finally, a 21st century commission would recommend that legal scholars and social scientists continue to conduct research designed to identify the decision rules that prosecutors use in making charging and plea bargaining decisions, and to pinpoint the legal and extra-legal factors that affect these decisions. Thank you very much.